SPS Rahayu Mahzam.
Thank you, Deputy Speaker. I thank the members who spoke in support of the bill. I would like to address the questions that have been raised earlier. Firstly, on Mr. Pritam Singh's questions on the threshold, with regards to the first clarification that he raised, what was meant is that the bill merely provides that the court must consider the matters in Section 60G(7). The court retains discretion to grant permission even if any or all the matters are not met. The bill sets out the conditions to be satisfied and the procedures to be followed and is enabling in nature. This is to advance the interests of justice. The statement by the spokesman referred to by Mr. Singh made the point that ultimately the court will retain some discretion because the bill does not absolutely rule out the exercise of such discretion. Parliament's intention is that such applications where the conditions in this bill have not been satisfied should generally not succeed, given the legislative intent expressed through the bill to set up a process to be followed. The court will exercise considerable care because there is finality, because we don't want to rule out the possibility. The framework sets out what the court will consider, and it is likely to be extremely rare for the court to go beyond this. So the intention is for the framework to be followed. You had a second question on the must not, the point of must not in Section 60G(15). The provision on abuse is about abuse by the applicant, not by the lawyer. And when they have previously abused the process, we think that Section 60G(15) is a fair requirement because the court can still grant permission if the requirements in Section 60G(15)(c) and D are met, which are reasonable requirements. And on the third point about reasonable diligence, there is a factor for the court. This is a factor for the courts to consider when deciding whether the evidence and arguments in the application could have been brought earlier. And this is not a new requirement. It is already in Division 1B of the CPC. Mr. Louis Ng had asked whether the court's power to take additional evidence can only be exercised on its own motion and about the grounds on which the court would exercise this power. The court's power to take additional evidence is exercisable on the court's own motion or upon the party's application. The court has discretion to decide whether to take additional evidence. Depending on the facts, possible matters that the court may take into account could include the nature of the additional evidence and its relevance to the issues before the court. Ultimately, this is a matter of judicial discretion. You had also asked Mr. Ng for more clarity on the meaning of the reasonable prospect of success, which Mr. Pritam Singh also touched on. The phrase reasonable prospect of success is meant to clarify that in deciding whether to grant permission to make a PACC application, the CA is to consider the merits of the intended PACC application. However, as the phrase makes clear, the CA is not required to conduct a full determination of the merits when deciding whether to grant permission to make a PACC application. Ultimately, the CA will be guided by the language of the provision, which is whether the intended PACC application has a reasonable prospect of success. To this end, it may not be helpful to focus on the standards mentioned by Mr. Ng because these have been developed in different contexts and it may not be applicable to the PACC application. Moreover, as I mentioned earlier, the CA has the discretion to grant permission to make a PACC application even if the CA is not satisfied that the intended PACC application has a reasonable prospect of success. Ms. Ng had also asked for clarification on the factors that the court should consider when determining whether an application is an abuse of process. So under the new sections 60G(15)(c) and D of the SCGA, even when there was a prior abuse of process finding, as I mentioned earlier, the CA may grant an application for PACC permission if 1. The PACP adduces material that was not adduced in court before the date of the most recent finding of abuse of process, and 2. The material could not, even with reasonable diligence, have been adduced in court before that date. The new Section 60M(2) of the SCGA sets out non-exhaustively some matters that the court may take into account in deciding whether to make a finding of abuse. For example, the court may consider whether the application is based on material that could not have been adduced before the relevant date, even with reasonable diligence. Ms. Hani So and Mr. Zulkarnain Abdul Rahim raised the questions about the quorum for applications for PACC permission. A PACC application cannot be heard and determined by a single judge. only an application for permission to make a PACC application can be heard and determined by a single judge. Having a single judge hear the application for permission to make a PACC application reflects the fact that at this stage, the court is only deciding whether permission to make the PACC application should be granted, and the court is not required to conduct a full determination of the merits of the PACC application. In a related vein, under the existing section 394H of the CPC, an application for permission to make a review application in respect of a decision of the CA is to be heard by a single judge sitting in the CA. Further, even in the case of an application for permission to make a PACC application, the CA has discretion in each matter whether to convene a quorum of 3 judges or a greater uneven number of judges. Depending on the facts, a possible matter that the court may take into account could be an issue raised in the application, and ultimately this is a matter of judicial discretion. Mr. Zulkarnain offered some suggestions to ensure the efficient use of judicial time for PACC applications. In line with Mr. Zulkarnain's suggestions, the bill expressly allows the court to make any incidental directions or give any interim orders as considered necessary for the management of the case, including a stay of execution of the capital sentence. And as to Mr. Zulkarnain's point about the time-sensitive nature of such applications, the cases have shown that the courts hear them urgently. For example, when a criminal motion was filed on 25th April 2022, 2 days before the PACP's scheduled execution, the court heard the matter the very next day, on 26 April 2022. Ms. Haniso asked about the written grounds of decision and whether the applicant can seek clarifications and make further submissions after applications are summarily dismissed. The bill requires the CA to consider the applicant's written submissions, if any, before summarily refusing an application. The CA has discretion to decide whether it will issue a judgment or grounds of decision together with or following the issuance of the written order. Any consequential matters raised will be dealt with by the CA. Ms. So had also asked about whether LASCO will be extended to cover PACC applications. Any such extension will have to be carefully studied in consultation with the relevant stakeholders before a decision is taken. Mr. Zulkarnain asked about cost orders against lawyers. All lawyers have a duty to conscientiously assess the merits of a case before engaging in court proceedings. If the lawyer thinks there is no merit, but the PACP insists on making the application, the lawyer should decline to act. The courts have observed that the filing of ill-considered and baseless applications by lawyers cannot be justified on the basis that the PACP faces a capital sentence. There are well-established principles on when a personal cost order can be made against a lawyer. It is for the courts, in the exercise of judicial discretion, to determine whether to make a personal cost order against a lawyer. In such cases, the lawyer will have the opportunity to be heard. Mr. Zulkarnain has highlighted the importance of raising international awareness and understanding of Singapore's approach to capital offences. We agree that this is important. Criticisms of Singapore's approach are often based on misconceptions and inaccurate facts. Singapore actively engages in international fora, such as the UN, as well as bilaterally to address misconceptions and explain our approach. We will continue to engage and raise awareness, and I thank Mr. Zulkarnain for his suggestions on how we can do so. I believe I've answered the questions raised by the members. With that, sir, I beg to move.
Are there any clarifications? The question is that the bill be now read a second time. As many as of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it.
Post appeal applications in capital cases bill.
Committee stage what day?
Now, Madam, I beg to move that the Parliament will immediately resolve itself into a committee on the bill.
The question is that Parliament will immediately resolve itself into a committee on the bill. As many as of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 5 stand part of the bill. As many as of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it. Bill to be reported. Minister for Law.
Madam Deputy Speaker, I beg to report that the bill has been considered in committee and agreed to without amendment.
Third reading, what day?
Now, Madam, I beg to move that the bill be now read a third time.
The question is that the bill be now read a third time. As many as of that opinion, say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it.
Post-appeal applications in capital cases bill.
Leader.
Madam Deputy Speaker, I beg to move that Parliament do now adjourn to 12 noon tomorrow.
The question is that Parliament do now adjourn to 12 noon tomorrow. As many as of the opinion, say aye.
Aye.
To the contrary, say no. I think the ayes have it. The ayes have it. Order. Order.